Well, I had already recorded and edited this week's episode, and then Justice Mosley of the federal court released his decision on the legality of the imposition of the Emergencies Act to crush the Freedom Convoy in February of 2022. So I figured I had to record another quick episode to take a look at that, and that's what we'll do. Hello, my name's Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. I'm sure all viewers of this channel are familiar, at least to some extent, with the Freedom Convoy, the great Canadian pushback against the various COVID measures, the lockdowns, the mandatory vaccinations, the closed border, etc., that happened in early 2022 and then was ultimately put down rather violently by the police. And we've done a number of videos on those topics. I invite you to check those out for more information on that. What's important as of today, being Tuesday, the 23rd of January, 2024, is a judgment has been released by the federal court. And that judgment holds that the government was not legally entitled to invoke the Emergencies Act based on the reality on the ground as it was. Now, this is a very interesting but also a very welcome development given the very disappointing results of the Public Order Emergency Commission that, contrary to the courts, ruled that no, this was all fine, the government was completely within its rights, properly used the act. As I said in my video reviewing that, I had hopes that when it got to a court with a judge with a full knowledge of the law, we'd get a better result, and so we have. So it's a 190-page decision. I read it very quickly. I'm just going to take you through the highlights. If you want a more in-depth analysis, leave comments in the comment section, and we'll look into doing that if we can. But for now, let's dive straight into it, and I'll give you a quick rundown of some of the key moments or some of the key decisions in this case. So here we have the case itself from the federal court. As viewers know, I prefer to look at the actual case, not mainstream or alternative media's summaries of these cases. So the case is frontline nurses and Kristen Nagle and the Attorney General of Canada, and also between the Canadian Civil Liberties Association and the Attorney General of Canada. There's a number of other parties involved in this. This is just how the case is stylized. I'm skipping straight through to page 99, where the judge gives the culmination or the conclusion of their analysis on the Section 58 invocation of the Act, which I've spoken about in previous videos. And as the court notes here, Section 58 states that violent incidents and threats of violence and arrests related to the protests have been reported across Canada. That's the explanation the government gave for invoking Section 58. But as the court notes, these reports were vague and unspecified apart from allegations that tow truck drivers in Ottawa had been threatened should they assist the police. That's a somewhat new one to me. I thought the judge was going to mention violence and threats towards truckers who were protesting, but in any event, this is all they had. And at the end of the paragraph, it's noted that there had yet to be any actual serious violence or threats of it, other than in Coutts, when the decision was made. The Prime Minister acknowledged this in his Public Order Emergency Commission testimony, where he said, "The fact that there was not yet any serious violence that had been noted was obviously a good thing, but we should not say that there was no potential for serious violence." So the court says at paragraph 292, the potential for serious violence, or being unable to say that there was no potential for serious violence, was, of course, a valid reason for concern. But in my view, it did not satisfy the test required to invoke the act, particularly as there was no evidence of a similar, quote, hardened cell, unquote, elsewhere in the country, only speculation, and the situation at Coutts had been resolved without violence. As we know, Coutts was already shut down when the Emergency Act was invoked. Coutts is a whole other story. I'm not commenting on whether the arrests there were just or on whether evidence was maybe planted or not. Just setting that aside, even if we assume that the government narrative of events is correct, the judge is saying that you can't compare Coutts, you can't use Coutts, which had already been shut down, with what was going on elsewhere. And again, 294 While these events are all concerning, the record does not support a conclusion that the convoy had created a critical, urgent, and temporary situation that was national in scope and could not effectively be dealt with under any other law of Canada. The situation at Coutts was dealt with by the RCMP employing provisions of the Criminal Code. So it says Ottawa was unique in the sense it was clear Ottawa police had been able to enforce the rule of law. But again, the court says that while the judge finds the Freedom Convoy protest highly objectionable, it did not amount to serious violence or threats of serious violence. And the court then reaffirms that the test for declaring a public order emergency under the Emergencies Act requires that each element be satisfied, including the definition imported from the CSIS Act. The harm being caused to Canada's economy, trade, and commerce was very real and concerning, but it did not constitute threats or the use of serious violence to persons or property. So for those reasons, the judge was satisfied that the governor and council did not have reasonable grounds to believe that a threat to national security existed within the meaning of the act. And therefore, the decision was ultra vires, meaning it was outside the power of the Governor General to invoke the Emergencies Act. The court then also went through a number of sections of the Charter, essentially assuming even if the Emergencies Act was properly instituted, was the manner in which it was done, does that violate the Charter? We'll skim this very quickly. So they cover the right to protest, freedom of expression, and the court agrees with the applicants that the scope of the regulations was overbroad insofar as it captured people who simply wanted to join in the protest by standing on Parliament Hill carrying a placard. It says it is not suggested that they would have been the focus of enforcement efforts by the police. However, under the terms of regulations, they could have been subject to enforcement actions as much as someone who had parked their truck on Wellington Street and had otherwise behaved in a manner that could reasonably be expected to lead to a breach of the peace. Again, not necessarily agreeing with the judge in saying that the truckers were wrong or people who were on Wellington Street were wrong, or I don't agree with the judge that people who weren't truckers were not subject to this, but the court, just to be clear on what the ruling is here, the ruling is that Section 2 of the Charter is violated by the fact that the regulations made under the Emergencies Act covered everyone, including people who are not truckers. Freedom of peaceful assembly, the court held that that was not violated. Paragraph 314, no breach of peaceful assembly. There's also no breach of freedom of association, according to the court. No breach of Section 7, according to the court. But then under Section 8, there is an argument about the freezing of bank accounts. Section 8 being the right to be protected against unreasonable search and seizure. Obviously, freezing a bank account is a serious search and seizure. So the court found that the failure to require that some objective standard be satisfied before accounts were frozen breached Section 8. Whether that could be justified in the circumstances depends on a Section 1 analysis. Long story short, the Section 1 analysis, the court talks about the minimum impairment required under the Oakes test, and in the end, the court found that the infringements of the Charter, Sections 2B and 8, were not minimally impairing, therefore found they were not justified under Section 1. So that's just a real quick overview of some of the key decisions and how those decisions were reached. Now, the government has already announced that they'll be appealing this. I anticipate this will go all the way to the Supreme Court, because at the Federal Court of Appeal, either the government will win, and therefore Civil Liberties Association and others will take it to the Supreme Court, or the government will lose again, and they'll go to the Supreme Court. I don't foresee the government throwing in the towel on this at all. Maybe if the Conservatives win in 2025, maybe they won't opt to appeal it to the Supreme Court if they've lost at the Court of Appeal, but this isn't over yet, but this is a positive first step. So again, if you want a more in-depth analysis, let me know. But this video itself is not legal advice. If you need legal advice, always call a lawyer. My contact information is below. You can call me or another lawyer. Show ideas. We're always open to them. Please leave a comment in the comment section or send an email to the email address listed below. And if you found this video at all interesting, helpful, or informative, please help spread the word, share, subscribe, hit the notification, follow us on social media.